Namaste and greetings. I, Shweta Shankar, researcher at IMPRI, Impact and Policy Research Institute, Prabhav Evam Niti Anusandhan Sansthan, Nai Delhi, extend my warmest welcome to you all to IMPRI, #Web Policy Learning. Today, we are gathered here for day 11 of Law and Public Policy Youth Fellowship, an online national summer school program, a 2-month online immersive legal awareness and action research certificate training course, and internship program. This program is organized by the IMPRI, Impact and Policy Research Institute, New Delhi. The chair for the program is Professor Vibhuti Patel, visiting distinguished professor at IMPRI, and the fellowship lead advisor and expert legal hands-on sessions is Advocate Dr. Shalu Nigam, visiting senior fellow, IMPRI. The distinguished experts include Shri Sandeep Chachra, Professor Vibhuti Patel, Advocate Dr. Shalu Nigam, Advocate Dr. Wahida Nainer, Professor Mukul Ashar, Professor Uday Shankar, Shri Udit Mishra, Dr. Nivedita P. Haran, Shri Bhartendra Singh Baswan, Dr. Purnima Chauhan, Advocate Dr. Albertina Almeida, Dr. Gladstone Xavier, Professor Aruna Roy, Advocate Audrey D. Mello, Dr. Kaustav K. Bandyopadhyay, Advocate Mrinalini Deshmukh, Professor Sharmila Ghuge, Advocate Flavia Agnes, Dr. Rashmi Singh, Mr. Debaditya Sinha, Professor Swaran Singh, Advocate Lara Jasani, Professor Anil K. Gupta, Justice Ajit K. Singh, Mr. Himanshu Shekhar, Dr. Amar Jasani, Dr. Soumyadip Chattopadhyay, Mr. Bilal Khan, Shri Rajiv Ranjan Singh, Shri Tikendra Singh Panwar, Shri Shailesh Gandhi, Dr. Simi Mehta, Advocate Abdul Hafiz Gandhi, Professor Amita Singh, Dr. Ajay Gudavarti, Shri Amit Dubey, Professor Sangamitra Acharya, Dr. Y. Suresh Reddy, Advocate Sanchita N, Shri Surendranath Tripathi. The conveners for this course are Dr. Simi Mehta, CEO and Editorial Director at IMPRI, Advocate Dr. Shalu Nigam, Visiting Senior Fellow IMPRI, and Dr. Arjun Kumar, Director at IMPRI. I welcome you all to this enlightening deliberation and thank you for putting your time, energy, and efforts into truly understanding the vital role and complex intricacies of legal and public policy frameworks. We have also shared the course outline and reading resources document in your email for your kind perusal. We will be providing videos of each session for flexible learning at your place and pace. Before we start today's session, I would like to announce the housekeeping rules. It is imperative that you join the meeting on time. There will be a Q&A session after each presentation. Share your questions in the Q&A box and not in the chat box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise and refrain from making general comments in the question to save time. Our session for day 11 will cover topics of an unresolved dilemma of anticipatory bail to juveniles under the JJ Act by Professor Sharmila Ghuge and Goa Children's Act 2003, a case study by Advocate Dr. Albertina Almeida. To start the session, I would like to invite Professor Vibhuti Patel for her opening remarks. Welcome, ma'am, and over to you.
Thank you, Shweta, for this opportunity. I would first of all like to thank Dr. Arjun Kumar, Dr. Simi Mehta, and whole IMPRI team of young hardworking activists. Dr. Shalu Nigam, today's the whole course is it's her vision. So Ms. Vidita, Satyam Tripathi, and Nikita, and welcome Professor Sharmila Ghuge and Advocate Albertina. Today, in the 4th week and the 11th session of this online summer school, we are going to have a very interesting debate, but so far, what we have covered is basically macro understanding of the symbiotic relationship between policy and the legislative structures and systems. And then in the 2nd week, we discussed about the mobilization at a policy level, advocacy, and at a ground level, how we do the participatory action research and also come up with evidence-based policy recommendations. In the 2nd week, we also discussed the policy initiatives and role of Indian judiciary. What should be the relationship of judiciary and bureaucracy, that means executive and the legal, to what extent, where are the limits, and can they interfere in each other's domain? And then we also had experienced bureaucrat like Dr. Nivedita Haran. She shared her experience of working as an IAS officer and how she dealt with both laws as well as public policies. In the third week, there was a focus on urban governance and a first-hand experience of Secretary of Himachal Pradesh, Dr. Purnima Chauhan. She discussed some of the best practices which were introduced by her to deal with the problem of declining child sex ratio in the border areas of Himachal, and also the implementation of the Rajiv Gandhi Awas Yojana. And also she shared several experiences of other countries and Sweden's urban government bodies, how do they function, and why we need to non-corrupt and accountable urban governance structures, which ensures less government and the most governance. And then we also had a session on peace, conflict, and social work, where Dr. Gladstone talked about the role of social workers in peacekeeping, peacemaking, and peace building endeavors. He dealt with several examples from global other countries as well as in India, and how the social workers had put in place very important initiatives, and he also discussed some of the best practices. Then in the fourth week, we had a very important session, because Dr. Shalu Nigam has been giving legal hands-on session from the very beginning of the course, and the fourth session also focused on the question of public interest litigation, and later on the torture and the freedom of press. Dr. Audrey De Mello, she discussed her first-hand experiences of building for 40 years of journey of Majlis and its work on fight against gender-based violence. And we also had Dr. Kaustav Bandyopadhyay, who spoke on the question of civil society. And he said that, how do you define civil society? And he also asked this question, and he also gave a panoramic view of the wide array of non-governmental and civil society organizations that have a presence in public life, and expressing their interest and values as members of the society in a nation building, and the importance of ethical, culturally responsive, politically sensitive, scientific, and also plural ways of worldview, and how the philanthropic consideration should be made. And he also said the role of civil society organizations for supporting the homeless, then in running the shelter homes, or providing the food pantries, and also various types of interventions they have seen to it that the government schemes can be accessible to the community. He analyzed the problematics in civil society and blurring the boundaries between political and civil society, and that's what means engagement with the with the political structure is very important. He said, what kind of civil societies do we have, whether it's a traditional or religious association or social movements or membership association, and they all are playing important role, and we need to engage with them, and we need to build evidences, we need to build awareness among the people, support the community for accessing government programs and their entitlements. And he also says that fragmentation can result in duplication of efforts and competition for resources and difficulty in achieving collective impact and collaboration. That is why CSR for CSOs and private donations sometimes become cause of concern. And that is what we need is we need to draw on the social capital, enroll volunteers, members, activists, and professionals. And I think there was a lot of, you can say, resonance in what Dr. Kaustav said from their experience of participatory action research, and the presentation very, very illuminating presentation by Dr. Aruna Roy and Advocate Nikhil Day about the work of Mazdoor Kisan Sangram Samiti in putting in place so many people-oriented laws regarding right to food, right to education, right to employment, and also for forest people's rights. So I think this is what we have done in last 4 weeks. Thank you.
Thank you, ma'am. We have Professor Sharmila Ghuge, faculty at JC College of Law. She will be taking the session on the topic and an unresolved dilemma of anticipatory bail to juveniles under the JJ Act. Welcome, ma'am, and over to you.
Thank you. A very warm good morning to one and all. At the outset, my heartfelt gratitude to IMPRI, Dr. Vibhuti Patel ma'am, Dr. Shalu ma'am, Dr. Arjun sir, other experts and all dignitaries, and the lovely anchor, comparer, and the researcher, Shweta, and the dear participants. So I have just been updated when I heard Vibhuti ma'am explaining all what has happened in the 4 weeks, and it indeed is a pleasure to be a part of such learning process, which has hands-on experience to learn a lot. So today we are going to discuss the unresolved dilemma and why do we call it a dilemma? So if I may share my screen and put up the PPT for the participants.
Please
just give me a second. All right. Is the PowerPoint visible?
Perfect. Please go ahead.
All right. In case there is a lag in voice or the PPT is not visible, kindly unmute and let me know. So friends, we are going to talk about something which has a bit of theoretical discussion and then hands-on, plus the challenge which I would urge the participants to look into since we talk about policy making. So the unresolved dilemma of anticipatory bail to juvenile under the Juvenile Justice Act. Why do we talk about it in the very first phase? So firstly, we will take a glance at the historical background as to how do we have the Juvenile Justice Act. 1 second, I'm unable to change the slide. Yeah. So when we say we have a Juvenile Justice Act in place in our country, which has been enacted after going through phases of laws, going back way to the British era. From the 1850, the Apprentice Act was the first law which was enacted in furtherance of protection of children. Then reformatory school. Thereafter, as per the 3 provinces which we had during the British era, the Madras, Bengal, and the Bombay province. So we had different Children Act. Then post-independence, we had the Children Act, which included not only children with alleged with offenses, but also various provisions for children in need of care. The same was continued and further enhanced with better provisions for children in 1986, the Juvenile Justice Act. This was a step taken by the Indian Parliament after ratifying the Child Convention at the International Forum. So naturally, with the International Forum, we were also making efforts towards protection of children in care need, as well as children who are in conflict with law. So the nomenclature, juvenile itself is somewhere traumatizing, and therefore we call it child in conflict with law. So we have had a very, very powerful amendment in 2000, then 2015 and 2021 with regards to adoption and other provisions for children. We are going to take a quick recap of the law on and whole, and then we are proceeding towards the discussion of ABA in juvenile justice and CRPC. So that's how we are going to channelize for you all to have an understanding as to how the flow is going. So basically, this is required to understand the object of the Juvenile Justice Act and why do we call it a dilemma. So object of the Juvenile Justice Act, which is a law provided for children who are either in conflict with law or are in need of care and protection. So the primary object of this law is highlighted for the well-being of children and the rehabilitation of children who are either in conflict with law or who have been in need of the rehabilitation. So one can say that the potential emphasized in the Juvenile Justice Act is care, protection, and reintegration of a child, whether in need of care or in conflict with law. Another interesting object of the Act is to have best interest of the child as the paramount core of this law, so that whether it is disposal of the matters with juveniles or whether it is care, what is important is the interest of the child, the welfare of the child. The focus is also accentuated on the difference of traditional criminal justice system and the justice system to be followed for the children. So overall, the core says the law aims at welfare, best interest, and restorative justice. We will also take a quick glance at the principles of Juvenile Justice Act. So these principles are laid down in the law so that they are followed by the board, Juvenile Justice Board, the lawyers, the parents, the litigants, and the society on an whole. So these are principles of presumption of innocence. As we always say, you can't term a person guilty unless proven guilty. Similarly, the principle of dignity, principle of participation, principle of best interest, principle of responsibility, safety, and protecting natural justice of the children. So various principles, I have cut it short to put it in one slide, but there are many more principles which are to be followed while dealing with cases of juveniles. I am aware in one of the session, I think in the last 1 or 2 sessions, there was deliberation on POCSO Act, there was deliberation on protection of children. So we are a bit on other hand, where we are talking about protection of children, but we are also having a touch here where children are in conflict with law. So it's not that the children are victims, but the children are accused of an offense. So we have the Juvenile Justice Act. Now, the point is, why in 2023, on this day in the IMPRI session, we are discussing about such provision which says there is a dilemma between ABA of JJ Act and the Criminal Procedure Code. So my friends, none of us are unaware of the fact that today the crime rate of juveniles has been increased by leaps and bounds. On and whole, if I take you back to the 1960s, you would hardly get crimes reported committed by the juveniles, very rare. Today in 2023, the statistics as per the National Crime Bureau has crossed the limits where one can say the involvement of children in commission of offenses has increased tremendously. So we cannot go by each statistics, but on and whole, to give you a glance, if you look at the chart on the slide, state-wise, so children are not only a list of offenses like theft, dacoity, robbery, etc., but also heinous crimes like rape, murder, attempts to murder, and various other offenses. So children are a part of these crimes, and therefore there is something which we need to talk in the question dilemma before us. Why do we have juvenile delinquency? So, but natural, we all are aware with the different era at our hands today, the era which I say is the most comfortable era human beings have ever experienced, and thanks to the technology. See, now also we can meet each other virtually because of the technology. But unfortunately so, somewhere the technology has been misused by the younger crowd, and therefore the increase of crime has a lot of chunk towards the internet, the televisions, the social media, and various facets of technology. So as I always feel that we float in the ocean of information, but this information depends how is it accumulated. Whether I'm accumulating the information for my betterment, or am I accumulating the information to do something wrong, commit a crime, and then come in the category of a child in conflict with law. So my friends, there are various reasons. The biological changes, hits on the puberty, the immaturity, the sudden changes in desires, and somewhere the children get attracted towards the sexuality and then run into the race of offenses if not guided. Urbanization, migration from small villages to cities, having no control, having no proper places to reside, residing in slums, getting in contact with other criminals or people who are hard criminals. Lack of family support, disputes in family, parents being separated, impact of Western culture to a certain extent, where a 16-year-old says, oh, I don't want to stay with my parents anymore. And then that is where all these reasons clubbing up together have increased the rate of juvenile delinquency in India. Poverty, illiteracy, of course, is one of the major causes. I will just take 2 minutes to take a glance at the Nirbhaya case, which all of us are aware. There is nothing new which I'm going to discuss, but my point here to put forth the dilemma has a close nexus to the Nirbhaya case, and therefore it is significant to have a glance at it. So, this was one ironical incident which rocked the entire nation into a great turmoil of pain and agony, questioning the system in our country. So on 16th of December 2012, Nirbhaya, a young physiotherapy intern named Jyoti, was returning after watching a movie and boarded a bus with her friend. Ironically, she was raped in the moving bus brutally by 6 men. Out of them, one was a 17 year, 6 months old accused. And this is when the turning point has come to talk of today's dilemma. Now, out of these 6 people, it is very sad to state. I always make a point that we need some sensitization as policymakers, academicians, and legal researchers, or any researcher. The sensitization points at a sentence which is on the slide, which you all can read, which says that during the entire monstrous episode of raping Nirbhaya, one of the accused inserted the iron rod in her vagina, pulled out her intestines, and that is where caused the greatest harm to this poor girl, and she succumbed to death because of the intestinal infection which she could not survive. This was one of the most brutal acts one can ever come across. In Nirbhaya's case, the youngest person, 17 years, 6 months old, was punished only with 3 years imprisonment, as that was the law in the year 2012, coming with the trial in 13. One accused committed suicide. One accused, as I mentioned, being a minor, was not tried on par with adult because the Juvenile Justice Act maximum punishment prescribed was 3 years. And then the person was sent to correctional facility. As I mentioned, there was a hue and cry in the nation. People with candle marches demanded amendment in the Juvenile Justice Act, requesting to lower the age of juveniles so as to have a deterrent impact in the society and on the criminals. But Justice Verma committee submitted its report saying we cannot go by the age. The psychological state of mind of a child is more important, and therefore the Verma committee report did not recommend lowering the age. However, with the efforts of policymakers, we had the amendment, and from 2015 onwards, any child between the age 16 to 18 is tried on par with an adult if he or she commits a heinous offense. So, my friends, the journey of Nirbhaya's justice went on from 2013 till 2020, when finally the accused were hanged till death on March 20, 2020. Now, the core point, as I mentioned here, is law at present, after Nirbhaya's amendment, says that any child between the age of 16 to 18 shall be punished on par with an adult if he commits a heinous offense. I repeat this because this is the core what we are going to have in our discussion. So we all understand any child below the age is a child under the Juvenile Justice Act as per the definition. Under the Act, we have a board which deals with the cases which come before the Juvenile Justice Board. In a minute, let's have a glance at the statistics, though I said earlier we cannot go in detail. But yes, my friends, one hand, we have this amendment. Children age group 16 to 18 can be punished on par with adult. On the other hand, we have immense augmentation of crime rate commission by the children below the age of 18. So if you look at 2011 till 2021, we have amplified the commission of crimes by children. And therefore, the point that if we have amplification of crimes by children, in that case, the child will be required to have some provisions of bail. Let us take a glance of what the law at present is with the procedures. So friends, the board under the Juvenile Justice Act is the body which is authorized to handle the cases under the Juvenile Justice Act. The board is constituted with its principal member and other members, and the board is authorized under Section 12 to deal with the provisions of bail. Now, please note, there is no word as anticipatory bail under the Juvenile Justice Act. The Act only has the word bail under Section 12. So any person, obviously a child under the age of 18, who is alleged of an offense will be produced before the board, who apprehends his arrest, shall be released on bail either with surety or without surety. The point is, my friends, Juvenile Justice Act, in its object, talks about welfare and interest of the children. Throughout the Act, it maintains this thread running through the fabric of the law to protect the children, to rehabilitate and restore the children and reintegrate in the society. But it does not mention about pre-arrest protection. There are reasons as to why it doesn't mention. Number one, the reason is that the law does not say that the child will be arrested, right? It says apprehended. There are these two words which are the core of our dilemma, arrest and apprehend. Now, if you look at the CRPC, the Criminal Procedure Code of India, the Criminal Procedure Code under Section 438 subclause 1 categorically states that a person apprehending his arrest can make an application under this provision, and if so, the Sessions Court or the High Court, if feel there is merit at the discretion, may grant the pre-arrest bail, which is commonly known as the anticipatory bail. Please note the word person includes a child, right? Because the age is not specified. So as per the general clauses, the definition of a person will include any person born till any age. Now let us take a glance at these two words which I mentioned, arrested and apprehended. So why is there absence of anticipatory bail in Juvenile Justice Act? The reason is, as I mentioned, the law says there is no question of arresting a child. The child will be apprehended if there is enough reason for the board to believe that the child needs to be kept in custody. The child will be sent to the observation home or will be remanded in the remand. And if there is no reason for the board to believe that the child needs to be apprehended, the child will be released. Therefore, the law does not talk about anticipatory bail. But as we took a glance about the statistics, the increase in number of crimes, there are questions where the children in conflict with law, their parents are fearing to approach the board with this thought in mind. What if there is no sufficient reason for the board to believe that the child can be released on bail and the child will be apprehended? There is no question of arrest. Whereas the Criminal Procedure Code clearly mentions about the word arrest. Thus, the point here is this kind of differentiation between the word arrest, apprehended, has created potential consequences for the children in conflict with law. And to make you understand this, I will just run through a few judgments which are ambiguous due to the nature of pronouncements which have come out from learned honorable high courts in the country. So on one hand, we have high courts who have agreed and granted that a child has protection under 438 CRPC, granting anticipatory bail. On other hand, we have high courts who have refused to entertain an application under Section 438 of CRPC, saying that it is implied under Section 12 of the Juvenile Justice Act. So, my friends, the point is, if you look at the Allahabad High Court judgment, which clearly says we have no issues in granting the ABA. I'll give you an example to simplify, which is a case on hands at present, which we are dealing with. So it's an interesting case. I'll close in another 3 minutes. All three in the case are juveniles. All are children below the age of 18. So here is a love triangle, 2 boys and a girl. One boy is 16 years old. One boy is 17 years old. The girl is a 16-year-old. These 3 are school children from a school in offskirts of Mumbai, which is known as Virar. These 3 were having physical relationships. And after a year of relationships, the girl is pregnant, right? So when she was pregnant, she was 15. At present, she is almost 16. The day physical relations have happened, the boys have now reached 17 and a half. So at that time, they were 15 and 16 and 17. The question was, who is responsible for this act? The father of the girl child went to the police station, registered a FIR against these 2 boys. Both are minors, I repeat. Now, one parent said that I don't want to produce my child before the board. I want an anticipatory bail because I fear my child will be apprehended and I don't want my child to be kept in the remand. One child, parents did not bother. He was produced before the board and he was apprehended. The parents came to us for the High Court and said, I don't want to try the Sessions Court. I want to apply for a bail in the High Court, anticipatory bail. Now, this is exactly the point which I am going to make out here. If such person approaches the High Court, what is the difficulty at the person's end, which we realized while handling this case? The person belongs to a below poverty line family. Naturally, they don't have the financial source, the manpower, and the time to come and rush to the court. So a litigant of a juvenile child is bothered to come all the way to the Sessions or the High Court for a grant of anticipatory bail, plus financial burden to apply for it. This is one major thing which I feel is something which we need to research and come out with a policy or a clarity. So moving ahead with other judgments, the Kerala High Court, the decision of Kerala High Court was that if you deny anticipatory bail under Section 438, it has no nexus with the Juvenile Justice Act. Rather, it doesn't serve any purpose. Moving ahead, the Gujarat High Court further clarified the difference between the word arrest and apprehend and said that we cannot go by the word apprehend and let the child suffer the risk or take the risk whether he will be released or he will be apprehended. And therefore, the child has a right to go for an anticipatory bail. Whereas, my friends, Telangana High Court, Punjab and Haryana High Court and Madhya Pradesh High Court have clearly refused to entertain applications under 438 CRPC for grant of anticipatory bail, saying that the same benefit will be under Section 12 of the JJ Act. And therefore, we refuse to entertain these applications. This is the dilemma. And that is the point which I would like to make, that if there is a judgment from the Honorable Supreme Court clarifying this position in the country, the litigants and the children who are alleged of offenses will be at ease and mind rest that yes, I have a right to go to the High Court for anticipatory bail, or I have an option or a remedy to go to the High Court. Or if it is clarified that no, only Section 12 of JJ Act shall deal with it, then there is no question of any litigant approaching the High Court or the Sessions Court for the grant of anticipatory bail. Therefore, considering the object of the Juvenile Justice Act, it is immensely significant to have clarity either from the Honorable Apex Court or with the amendment to that effect adding on in the Juvenile Justice Act by the Honorable Parliament of this country. So there is a lot of scope to go for research, and I always feel the more we research, the better we learn, the more we reflect, the better we live. So this is the point I wanted to make. I think I have made it in time to open up the discussion for question answers. I'll be happy to have any questions from the participants.
Thank you very much. Thank you very much, ma'am, for shedding some much needed perspective. Now I request Professor Vibhuti Patel to share her remarks.
Thank you, Professor Sharmila Ghuge, for making such a sensitive and also logically sound presentation. My major worry is about this whole differentiation between boy and a girl, in especially where there is a consensual relationship. Why do we treat boy as a child in conflict with law and a girl as a needing protection, no child in need of care and protection? Where is girls' agency? Because if you see all the Bollywood films, Hollywood films, Netflix, Amazon, everywhere they are valorizing adolescent love affair, no? And even if we see like all around, people fall in love, and liberal parents don't, they take it in a very democratic way, but always why criminalize the child? So that is my one concern. Second one is that when you come to talk about the rehabilitation, the TISS report shows how the rehabilitation centers, states after states, have a gross violation of rehabilitation center. Most of them have even become the dens of traffickers and pimps, no? So what can we do to ensure accountability, transparency, and also allocation of budgetary? Because the unit cost for rehabilitation center is so scanty, you can hardly give them nutritious meal, no? And so many of them run away en masse. In fact, I have been in a committee of this thing where some 14 girls, they ran away from the rehabilitation committee, and the state government had asked her to. And when he asked, the police tracked them. But when we asked, the condition was so deplorable. So what can be done in the rehabilitation part? So these two responses.
Yes, ma'am very aptly put forth the first point which you mentioned. And therefore, in the session when I spoke about the technology and internet, so this is what exactly I meant. Today, we have web series all over, and children are glued to the web series. And as you rightly mentioned, if we are projecting such kind of adolescent love stories, children of tender mind, they are bound to imitate these things. That's what is happening. So first of all, how much
you see those musical channels, no, and Instagram,
yes.
10-year-old, 5-year-old, some 8-year-old boys and girls, they
yes.
are dancing to Bollywood number with the same body language with the heroes and heroines, no?
Yes, exactly.
And how do you, with such a sexually charged environment, how do you criminalize boy and just say that girl,
the girl is a victim? I agree on this point, and therefore we need to also understand that the girl is equally responsible. You know, the case which we have, we are really disheartened to read all the facts of the case where the girl has consensually been in a relationship, but merely because the law says consent below 18 is not a consent. So we would require a change in that as well. Coming to the point of Bollywood and all the things going on around. So we, as we are aware, we have a broadcaster's right, the children performers right. Now that is where either under the name of freedom, liberty, we are getting carried away without understanding the adverse impact of all these things. So the children performers right allows them to perform as equal as an adult. And that is something which we need to have a fresh look as a society on a whole. Secondly, coming to the rehabilitation and the mishaps which are happening. So, ma'am, as a person who's being always charged to file public interest litigations, I can see there are two things. One, that we need to have inner conscious awaken of the society, which is a very difficult task. If that had to happen with civilization, we would have been better human beings and we would have had less rate of crime. But when we say we are more educated, more civilized, we are having higher crime rate. So that doesn't go with education and civilization. Civilization in terms of valuing human values and respecting individuals is a different thing completely. So first is there is need of social awakening. Whoever is the warden, whoever is the in charge person, himself, he or she needs to value that they are children who have come for protection and not to be trafficked. So that is one very ideal perspective which is difficult to achieve. Second one, which I feel a prudent way to deal with such things which happen, is approaching the courts. So many a times when we file, I mean, Shalu ma'am is also there, she will certainly agree that if there are these things, we file PILs, we know sometimes the courts are also not very keen at PILs, but then we have to make it a point that this is what is happening. After a court direction, at least there is some hope that the situation will improve and there will be some kind of monitoring. As you yourself are on so many committees, ma'am, I feel even the committee inspections and the committee check balance system would also help us to have a betterment of these activities.
No, in Maharashtra, okay, you have, but I think each state, it should be mandatory, transparency.
Yes.
Why should there be iron wall of secrecy around shelter homes? It's so difficult to go, at least now because of the child rights movement in the certain states like Chennai or Bombay or Bangalore. We have that kind of access where we can take our students also for a study tour, they interact with children. But elsewhere it is not there, no? So
It should be.
Universal, nationwide umbrella law.
Yes, ma'am.
Thank you. Thank you.
Thank you.
Excellent.
Thank you.
Thank you, ma'am. Now I request Shalu ma'am to share her remarks.
It's very insightful and wonderful presentation. So thank you for that. And surely you have rightly said that we go to the courts, we file PILs, but not much thing is happening on the ground. So I'm really wondering, what should we do in the terms of prevention of such crimes, because certainly we have a National Commission for Child Rights Protection, all those kinds of bodies are there, state agencies are there, but again, the crime is not, as you have rightly said, crime is
it's increasing.
Yeah, it's increasing. So, like, in terms of prevention, if we could throw some light with your, so much of experience that, if we can take some step as like in terms of policies also, if there could be some policies which could be, which could help to address this kind of issue, because the law and agencies are somehow,
I understand, ma'am. So thank you so much, ma'am, for your lovely words. At the outset, let me even share with you all in a minute that when we say we file a PIL and we know what's the result. So around 8 years back, I had challenged the AIB roast show, the Karan Johar's AIB roast show, which was very vulgar according to me. And therefore, I challenged it on the grounds of decency and morality. So to be honest, on the first date, Honorable Justice Kanade sir asked what is the full form of AIB, and Mr. Jethmalani was representing Mr. Karan Johar, and he could not pronounce the word full form of AIB. He said, "My lords, it is All India dash dash dash." So my contention was that if you can't pronounce the full form of the show in the open court, you expect me to sit with my kids and watch such a show which was available on air everywhere. My concern in challenging this was that by projecting these things to masses, you are providing a wrong pathway to the younger generation. And that is where the children are somewhere magnetized to commit wrongs. This is not we as a society should look at. Okay, we cannot be countries like banning internet. That's not the point, but we can streamline things. Plus, when you say what can be done as a policy, ma'am. So honestly, over the years, after working for children, women, and I personally work with tribal people a lot because they are the ones where these facilities sitting in AC room, having a laptop doesn't reach. There we have to sit under a mango tree and discuss. Vibhuti ma'am is very well aware as she is a pioneer of these things all her life. So ma'am, I strongly feel that we should have awareness sessions at regular intervals. First and foremost it is the torch bearers like you and me, people who are aware, the academicians, the lawyers, the public spirited persons, the policy makers, they should make it a point to give some takeaways in their session. Like if you ask me, what is the root cause of these things? We know root cause is the gender discrimination. So more the gender discrimination, we target in the bargain to protect the girls, we target the boys. So why do we bring up girls and boys in a different manner? This is with regards to the sexual offenses which are committed. But on in general, these days we see juveniles killing grandparents, stabbing grandparents for money, committing thefts in their own house. So overall, ma'am, I feel the whole culture has undergone a sweeping change in our country, which we can do better. One, policies, by making laws more clear. Second, actions of check and balances of having various committees in place. Third, being people who can be the torch bearers to commit sessions, to commit awareness camps, road shows, so that people are aware at large and be ready to raise a voice against every injustice which we see, which few people do. So I feel this is a multifaceted problem which needs a multidimensional approach to control and curb it.
We have one question also.
Right, we have 2-3 questions, but let me also add one thing here, ma'am. In Delhi NCR, we found that there is a lot of chain snatching, mobile snatching on the roads, and all are juveniles, and they are so free, and almost they pretend like they are protected by somehow. So it's very common here in Delhi, other than the gender crimes. That's also happening. I'm not sure whether it's happening in Mumbai, but in the garb of law, that is also coming. Some very good questions we have got. Charuji, would you like to go ahead? Then Garvit.
Yes, so my can you hear me?
Yeah, we can hear you.
So my question is around the term that you used, heinous crimes, heinous acts. So is the definition of heinous act very clear in the law?
Yes, Charu, the definition is very clear. We have offenses which are categorized as heinous offenses. For example, dacoity, rape, murder, all these kinds of offenses are heinous offenses. And the punishment for heinous offenses will always be described differently. The law itself clearly mentions so.
Okay, thank you.
Garvit.
Hello. Yeah, I hope I'm audible.
Yes.
Point of reply to just ask a question about the thing about AIB. So what I don't really understand is that yes, AIB as a show isn't really what you would call sanskari per se. But doesn't that we are putting on AIB? I do not know the content which against which the PILs was formed, but if you're shifting the onus of teaching our children values from like homes, schools, and caregivers, and then putting it away and giving it to filmmakers and artists, isn't that a lesser responsibility on our part? Because we cannot ask individuals who are artists and creative people to police themselves and their desires and their art so that they can suit our morality. Isn't it better to have our own free choice and rationally considering what is suitable for certain age groups and individuals? That's my only.
Yeah, Professor Sharmila, please also explain AIB in detail.
Okay, ma'am, I will. Yes, so thank you, Garvitji, for your question. So, All India -- because it's again against my morality to pronounce the word on such a platform. So, the name of the show is AIB, which was a show which was taken in a club in Worli, which was attended by various film stars and other dignitaries. For which they bought a ticket and they attended. So they were a party to it with their consent, and it was above age 18. Now, this show was hosted and acted by Karan Johar, Arjun Kapoor, many other people from the Bollywood, and was attended by Deepika Padukone and other film stars, which I won't name, but they are a part of it. So the content was in the four walls. After that, the show was put on air. It was uploaded on YouTube. We have a disclaimer that children below 18 should not view it. We all know that it is only for the sake of words. And in reality, any age child views any content. There is no control of any password or any parent, I would say. Now, my concern was I had not been to the show. I had no idea. When it was put on air, I had a client coming to me, said, Madam, I want to draft a police complaint against the show. It is against the culture of the country and it is blah, blah, blah. So I then thought, okay, let me see what it is. After that, I went on YouTube and I saw it for myself. The same day, I had a lecture on constitution in my classroom, and we had a lot of deliberations with regards to what the young generation feels. So, Garvitji, to give you a brief, since you don't know, there were certain I would not be able to pronounce, but yes, one of the objectionable statement was that Karan Johar makes a statement that if Preeti Zinta was in the audience, she would have enjoyed the show as if she was -- by 1,000 men. Then one was, okay, if you are, anyways, I'm sorry, I won't be able to make more statements because it's not proper to even pronounce the words. So overall, the body language, the words, the actions, there was a replication of a sexual intimacy scene on the stage, which was made between two men to depict how intimacy takes place. There were many things. I have a huge transcript which I prepared while filing the PIL. My point was, we have freedom of speech and expression under Article 19(1)(a) of the Constitution. However, we have a reasonable restriction under Article 19(2). One of them is decency and morality. Sadly, the word decency and morality has not been defined anywhere in the Constitution. So what is decent for me may be indecent for somebody, and vice versa. So pronouncing the words in such a manner in open public, talking about rape as a joke, raping a woman would be an enjoyment, is indecent according to me. But it wasn't indecent according to the audience and the producers and the actors. So on various grounds, I challenged this. My contention was that the content which is in four walls is with the consent. But when you put it on air, it cannot be the same because the class who watches it is different from the mass who views it. The impact on Deepika Padukone will be zero, but the impact on a child of 12 years will be, oh, this is what the film stars are doing. मेरे को भी ऐसा करने का है, मैं भी ऐसा करेगा. And that is where the children get into a wrong zone of life. And somewhere I felt that roast show is a routine of Western culture, not a part of Indian comedy. Of course, the youngsters do like it. I'm not on a point to suppress the freedom of speech and expression. I'm on the point to have a bifurcation of what a person under 18 can view and above 18 can view, because above 18 has the majority to understand what is good. Well, after the PIL, the court ordered on the very first date to take off the show from air, and Mr. Karan Johar tendered an apology for the same and took the show off air. Thereafter, the show was again back on air with certain modifications, but the PIL is still pending. And as I mentioned some time back, the courts also sometimes take their own time to decide public concern. Coming to your point with regards to what right do we have per se, to tell children not to do this or to restrict the artists. The point is not that. We are not trying to shift the burden on Bollywood, but understand one thing. Whatever is seen in Bollywood or web series or any form of media which portrays such kind of activities, it somewhere shows the reflection of the society. It is said that it is the mirror of the society. So it's a situation where you cannot clap with one hand. The society is equally responsible as responsibility of the Bollywood as well. You go back to 1970s, Garvitji, you will see the movies are so different. Even to show a kiss, there used to be either, there would be a page which is held like this, or they are behind bushes or behind flowers, roses, but kiss bhi nahi dikhai deta tha. Today, if you see, all kinds of sexual activities are explicitly shown even when there is no need of it. Somewhere this kind of exposure makes an impact on the young mind. I come back to the point that it is not the Bollywood which is doing it, it is the society which is loving to view it. So we can't blame the Bollywood. Point is, we as a society have changed, and now there is time to change for better. So somewhere it is my responsibility to make my children understand what is good, what is bad, to raise them equally, instead of saying, okay, the girl is become 16, so you learn cooking and the boy be a king. No, we have to see that we have proper upbringing, proper cultural, I would say the cultural impact, the imbibing of moral and ethical values is the real key to overcome such kind of social scenarios with the help of policymakers and law, of course, because law will ultimately have a deterrent impact on the wrongdoers.
Right. Really thankful for your points. I just want to ask a few questions on that, because I think you're not really. Let me just rephrase what I meant. So just to give you an example, as you gave many examples, I have a little sister, and she also, like me, watches Netflix and Prime Video. And I think one rule that we have simply in the home is that if something is UA 13 plus, she will not watch it. She's 15. She does not watch it. And that's what I simply mean by responsibility. And if somebody, I mean, the disclaimer, the point of a disclaimer and the rating is that when the audience is consuming it, it takes care of its own consumption. Because when we try to offlet, police the supply of these things, when the problem here is at the supply, is at the demand side of it. Because we as consumers are not responsibly consuming them. Like if I am sitting right next to my sister and she's watching an indecent scene, it's my responsibility to police it, and it's my responsibility to like inculcate such morals in her that when she sees it, in a sense, when she knows that it's 015, she will not watch it herself. So on that end, policing someone's art and desires is, I think, not the proper way to going around it. And the second thing, you mentioned the fact that what's moral and immoral is very much subjective to ourselves. But isn't what you're doing basically when you file a PRL against such a show? Well, I have no support for the sort of content that they're showing about rape jokes. I abhor it. But once we undertake such a legal action against shows, aren't what we're doing is basically using the power of the law to create an, well, an unobjective standard of morality, and we're saying that, oh, hey, it's objective and you have to adhere by it. And even more so, you mentioned, say, things like that kissing was considered to be indecent in those times. Well, as we know, India is progressing very much, and while I wouldn't call any of these things proper to be showed on TV, and that's why we have age ratings, but to say make kissing or sexual attraction or relations a taboo, I feel that's much more regressive and much more, I would say, anti-progress for our youth. So wouldn't the processes of filing a PIL, just because we are not as a society policing our own consumptions and teaching morals to children, so shouldn't we be doing that on our own end instead of telling other people to not produce content?
Okay, so Garviji, coming to your point, what you spoke is 20% of the country. I hope you are aware that 80% of the population of this nation resides in rural part, who do not understand what is a differentiation between 15 years under 18, or the disclaimer, or I should not view, or I should view. No, let me tell you, the life in real India is very different. Coming to the point, I agree that I'm not trying to make a deterrent here by, okay, this is morality and this you should do. The point is, if you may get the prayers were on the point that there has to be a monitoring whether the person below 18 is viewing it or no. There has to be filtering of content. I come back again on the same thing, that we are not trying to imbibe on somebody that, yes, this is moral according to me and therefore it should be. Neither am I trying to say that kissing and this is a taboo and that should not be seen. See, understand one thing. A society has different phases, which as law people, we've studied from the 10th century till date, how the society has changed and how the law has changed. So today, adultery is not an offense in India, which was an offense till 2018, punishable with 3 years imprisonment. Adultery has never been an offense in European countries. Adultery is an offense punishable with death penalty in Gulf countries even today. Why? Culture is different. Society is different. Time is different. You cannot have the same concepts for all the nations. I personally believe that there is no greatness in showing kissing and physical intimacy and sexual scenes on screen and saying that we are progressive. I'm sorry, I may differ. I mean, I would beg to differ on this point. My way of looking at progress of the nation or development or civilization or education is different. It does not depict on these things. Neither do I view these things as to be suppressed. But I feel, what is the need? Is there a necessity to show a particular act? If it is medically required that, yes, I am giving sex education to a child and I need to make the child understand the consequences of this act, I would say, yes, I need to explain it with detail of those body postures and the intimacy. But otherwise, for entertainment, my personal opinion, we do not need it. And I would say this should not be a part of freedom of speech and expression, because somewhere this adds on to the adversities and the situation in the country. So of course, you have your views, I have my views, but then by filing a PIL, I do not feel that I have made an attempt to suppress somebody's creation of the content. My concern was to filter the content and to see that the content goes to the right people. I agree that it is our responsibility to see that we impart moral values. Like you said, if you don't allow your sister to watch in your presence, she will not even watch in your absence. But how many children of this country actually do that? How many parents of this country actually make efforts to make that moral line so strong? On the contrary, Garvit, let me share with you, uh, by interacting with so many parents over the years, the parents say the more we tell the children not to watch, more is the anxiety to watch it, and to watch it in a wrong manner by sitting with more friends in corners and doing it. So therefore, every person will have his, her different views.
Garvit is uh, very aligned by the artist. So Garvit, why don't you take this with Professor Sharmila Ghuge over email or contact her and learn more?
Certainly. I have given my email ID. I'll mail you this PPT. So you all have my mail ID and you can please be in touch with me. I won't mind.
Garvit, do engage with ma'am with the purpose of learning and not just, but very good discussion. In view of time, we will move ahead to the next, and maybe if ma'am will stick around, we will have more questions, because many more questions Mohammed ji is also asking. So shall we start with the next session? Because Advocate Dr. Albertina ma'am also have some cases lined up. So we'll start on time. Thank you so much, Professor Ghuge.
Pleasure. Thank you.
Thank you.
Moving forward with the next session, we have Advocate Dr. Albertina Almeida, who will be taking a session on the topic Inclusion, Laws and Policies. Advocate Dr. Albertina Almeida is a lawyer and human rights activist based in Goa. Welcome, ma'am, and over to you.
Albertina ma'am, are you able to hear us? Yes.
Hello, and I guess this is my third session with you. I'm seeing you all again. This time I'm going to look at some processes that were followed in terms of ensuring that there is an inclusion both in terms of the content of the law and inclusion in the processes towards lawmaking. So therefore, I will share with you what has been the experience with one such act, one such law that we were involved with the process of enacting, and that is the Goa Children's Act. I do not wish to state that it was all without any difficulties or without any challenges, and that everything went smoothly the way we wanted to. We had to keep struggling to ensure that it was participatory, and it may not have been totally participatory still, but there were some pointers to how we can make it participatory in order to be inclusive. So therefore, I'm basically talking of participatory processes with the Goa Children's Act as an example. So I will make a presentation to so that again, I stick to my time. So as I said, I'm talking both of the law being inclusive and the law making process being inclusive. And
ma'am, can you go full screen also? Full screen. You can go to slideshow on the top. If you're on Zoom, just beside that there is a
just a minute. I always get the whole thing goes.
I will get it fixed this time. Ma'am, can you see on the top, left top, file, home, insert, draw, design?
Yes,
file,
yes.
Transition, animation, slideshow. Transition, draw, design, transition, animation, slideshow.
Slideshow.
Go to slideshow, start from beginning. Click there.
I clicked on slideshow.
Yeah, can you see start from beginning? No?
Start from beginning. From beginning.
Yes.
Okay.
Perfect.
Yeah. Yes. So as I said, this we have to look at inclusion not at two levels when it comes to lawmaking. One is at the level of the content of the law. How do we make sure that the law is inclusive in terms of addressing the concerns in respect of that particular subject, and also how is the law inclusive in terms of the processes so that all voices are taken into account in this lawmaking process. And I think this is also important given so many other areas that are emerging today, and where there needs to be a discussion and a participatory and consultative and inclusive, more important, inclusive process, given the diverse nature of stakeholders in respect of any issue, and the current one maybe being the whole discussion around uniform civil code. So so let me just begin. How does one how do I go to the next slide?
Ma'am, bottom left, can you see the arrows? It's
Yes,
kind of
bottom left.
bottom left.
And
Yes.
towards the left.
Yeah, bottom left, extreme bottom left. Yes, just behind that.
Yes, yes. Okay. Thanks.
There are the keys here.
Yes. So what does the Goa Children's Act cover? Okay. Yeah. So it covers areas such as education, health, and nutrition. It covers the subject of children's homes, child labor and trafficking, commercial sexual exploitation and dedication, children in difficult circumstances, girl child, differently able children, and then all rights under the Convention on the Rights of the Child. And if we have higher standards, then plus the higher standards in terms of rights and rights of various stakeholders. So these are various areas that the Goa Children's Act covers. Now, normally, until that point of time, a lot of the legislation was around sexual abuse of children. That also, it was within sections in the Indian Penal Code. The POCSO was not there at that time. But after that also, the POCSO came to be enacted. But the POCSO is covering basically protection of children from sexual offenses. So this law was seen as a way, it was like a code on the children. That was the idea. And now why did this come about? Because we realized that when we were following up on cases of child sexual abuse, for example, we realized that, why always be restricted to, having to engage with the law at the stage when somebody has already been abused. First is, what are the reasons? Because we were not engaging with them only from the point of view of taking up their cases in the courts. So we have, as organizations, we have been engaging with the children also from the point of view of engaging with them compositely, in terms of their needs, their requirements, trying to address their vulnerabilities. So we realize that there are various vulnerabilities that children have. They do not have access to education. For example, if they don't have proper access to education, then they cannot be enrolled in school. Then you come to the next level of issues, then what do you do? Then the children are just roaming around the street, become vulnerable to child sexual abuse. Now, at that time, the Right to Education Act was also not passed. But even after the Right to Education Act was passed, often when children are to be admitted in school, especially when it comes to migrant children, the school is asking for the birth certificate. Now, many people do not have birth certificates, although here in Goa, it has been a practice, but then migrant children very often do not have birth certificates. And then the question arises that should they be not admitted simply because they do not have birth certificates, as was the case before. So therefore, they need to have, there needs to be a process by which the school should not deny somebody admission. They can then, if they want, see whether who should be the guardian of their child and whether that person is actually the parent, not, etc. All that can be seen. But the bottom line is that the child should not be denied education in school. So these are the procedural aspects where the whole law, fails. So therefore, we talked of right to education, that every child has to have an education, has to have access to education. And we're talking not just of that it is mandatory, but we're talking of the process by which the access happens as well. So therefore, we incorporated this aspect of, we felt that the aspect of education needs to come in. Similarly, when it comes to health, the vaccinations, etc., some kinds of procedural issues that arise. So therefore, we incorporated health. Then we realized there's also the question of nutrition. Now, because if children are not healthy, many times it is that why are people working in exploitative circumstances? Because at the end of the day, they have to have a meal on the table for themselves and their children. So if that is so, then the point is that the issue is of nutrition of the children. And therefore, how can we address that aspect? These were one set of issues. Then there was the whole question that as far as children's homes are concerned, because there are various dynamics that operate with homes, and then there is the question of homes by different homes that are run by different kinds of formations. We had also the experience of a case where someone was pretending to be a benefactor. The famous case of Freddie Peets, for those of you who have been engaging with law as well, maybe. This case where this man pretended to be somebody who was like a godfather, like or a Santa Claus or something to that effect, and people people who from dysfunctional families, etc., felt okay, somebody's taking care of their children, and then he abused the whole process because it was nobody was questioning his processes because what he's doing inside the home, because the whole thing was my child is being educated at the end of the day, my child is being taken care of. A woman, for example, if she has to work, the husband is drinking and squandering away the money, etc., and then she has to work and she is not able to take care of the child, therefore. So then this children's home was an ideal because it took care of the financial thing, as also the attention that may be required, which she may not be able to give. So therefore, this whole issue of children's homes. Why I'm talking of this is because very often people sometimes think of legislation because there is some legislation somewhere else or whatever. But here was a situation, it is a legislation has to emerge from the needs and situations that are developing. So here was this whole law and how it was visualized. It included all these concerns, because if you're talking of child sexual abuse, okay, there is a penalty for child sexual abuse, but there is and it's declared an offense, but there may be so many other aspects that are there. As I said, the vulnerabilities for the children, and not only vulnerabilities to child sexual abuse, vulnerabilities to exploitation, vulnerabilities to oppression. So therefore, why not deal with this comprehensively? So therefore, because one thing leads to another, when you're dealing with a case, then all these aspects arise. If the child is abused and is vulnerable, how can the child be housed? What about escorting the child? All these issues arise as well. So that was one area. Then was the whole area of then was the whole area of child labor and trafficking. Commercial sexual exploit, because now here we're talking of child labor and trafficking other than the trafficking for sexual exploitation. So this is that kind of trafficking where there is no defined purpose. It may be, let's say, sale of children, for example, because we realized when we were doing a case, this, as I said, it has evolved from engaging with children, engaging with situations that the children have been in. So we realized there was a woman came, somebody came to us and said that children are being sold and from a clinic. So therefore, we kind of did a decoy operation, and we pretended to be people who are buying the child and want to buy the child, are interested, and we are a what you call childless couple, etc. And then the home sent us to the brother of the person who was the doctor who was managing the home. And then when we went there, he promptly issued a medical document to the effect that the child was born in the home and these are the parents, meaning the fake parents that we pretended to be, and handed over the child to us. So that this was the decoy operation, operation done. But finally, we were grappling with the law. The Indian Penal Code had no provision for declaring for treating sale of children as an offense. You could, if you sold a child for the purposes of prostitution, if you did a commercial transaction for the purpose of prostitution, then that was an offense. But sale of children without setting out where you can't establish the purpose or whatever, but sale of children, that was not an offense. And then here was a situation where in all probability, the woman had abandoned the child. But we know that, when these kinds of sales take place, there is every possibility, one, that the woman may have been browbeaten into abandoning the child. Second, maybe she abandoned the child because of her circumstances. But there is also a possibility that those who are buying may buy them for exploiting them in a circus or for other purposes, for organs, for etc. So all these issues were there. So therefore we felt that sale of children needs to be an offense. So therefore all this came within child labor and trafficking, that's section. It was not styled in this manner. It was then amended along the way. But broadly, I just want to say that these are areas that were not covered, and we felt that these need to be included because here are these kinds of vulnerabilities and these situations need to be included. Similarly, commercial sexual exploitation and dedication, because how there is we don't anymore have a process of dedication in Goa, because the first chief minister, first of all, belonged to the community that used to be dedicated in a sense. But so he believed that this has to change through a societal transformation. And in that sense, it did have effect. It is true that it had effect. But we have an entire migrant population that is dedicated, and where those who are dedicated are put into commercial sexual for commercial sexual exploitation. Therefore, we felt because there are certain processes involved in the dedication, if you just put it as exploitation, then the ingredients of sexual exploitation are different, and there are certain different ingredients when it comes to dedication. And we didn't want to wait till that dedicated child is actually sexually exploited. So therefore, we felt that we have to also consider this aspect. Now, this came from the experience of those who work on issues of trafficking, where it was found that if somebody is dedicated, you couldn't do anything, and you had to wait till that child is sexually abused and then book an offense for commercial sexual exploitation. So here again, it was a needs-based process. Then there are many categories of children in difficult circumstances. I will come to that. But just to say that there are these are children who might be recognized at one level in terms of the under the JJ Act, but not in fully in terms of their vulnerabilities for various kinds of rights violations. So therefore, and it is not about just about putting them in homes or taking care of them at that level. There are more issues around it about rights violations. So therefore, we felt, for example, they can be abused. I'm not talking just of sexual abuse, but other forms of abuse. So therefore, we said that children in difficult circumstances needs to be a category that would ensure that other kinds of vulnerabilities of children would be addressed, other than the already recognized vulnerabilities like child labor or child sexual exploitation or dedication. So that's how. Then we realized, of course, we're talking of children, but girl child needs special attention because of the vulnerabilities like in any other part of the country. So therefore, girl child came in the picture. Then differently able children, as you know, there is now a Persons with Disabilities Act as well, but when it comes to children, so that there's a focus, and there are other issues that have that end up getting discussed also in terms of how will should the children be with other children in school, or should there be special schools for these children? All these various other aspects also tend to need to get discussed. Data needs to be put together, etc. So therefore, a section on differently able children, and then also covering, as I mentioned, there are many rights now. There are many rights guaranteed by the Convention on the Rights of the Child, but there is no legislation to that effect. So we felt that all these rights there must be a legislation, because it's not enough to say, then you'll have to go in a writ petition to the High Court if some right is violated, if there is no specific legislation, so which has its mechanisms and procedures in place. So, and everybody cannot go to the High Court with a writ petition, etc. So to say how this issue needs to be addressed, etc. So we said, let us bring on board the entire Convention on the Rights of the Child. And however, we might have higher standards. Somewhere evolved higher standards, then we might have evolved, or somewhere in the world, there may be higher standards evolved, which we would like to follow. So we should not also be limited by the Convention of the Rights of the Child. So this was like broadly, this was like our wish list based on the needs and experiences of engaging with the children and of also the children's articulations. So therefore, this is how we visualize that the law should be what the law should cover in terms of inclusiveness in content. So as I said, we brought on board this category of this category of children in difficult circumstances. And here we were looking at a child. What does a child in difficult circumstances mean? A child in difficult circumstances means a child in need, exposed to or likely to be exposed to child abuse or sexual offenses or child trafficking or commercial sexual exploitation or violation of his or her rights. So that doesn't mean only if they're already exposed, but they are likely to be exposed. So what measures need to be taken for their protection? So therefore, the child in need, who is all this? And then we define the child in need. The child in need could be child labor, street children, a child who has been dedicated, a child in a home registered or otherwise, a child in foster care. These are also people who can be vulnerable. So we tried to identify as many as possible, but we meant all these children who are vulnerable and tried to set out some of the categories explicitly. And therefore, that's the last one, a child who is vulnerable. Because to cover also still other things that we may have not specifically brought on board, or we may have overlooked because none of us are working on those issues. So children of prisoners, etc., all these things. And so therefore, these categories were set out in terms of who are the children in need. That means children who are also of parents children whose parents are separated or divorced, a child who has an illness or disease or ailment which has a social stigma attached to it, example, HIV or leprosy. Now, as I said, it covered all those areas, but now does it mean that for all these things now everybody has to rush to the court if there are problems in all these areas, which we covered? Doesn't help, because not everything is a criminal offense. For example, if a child is not being admitted to school, then one can go to the education department saying that, see, we have a very clear provision that just because somebody doesn't have a birth certificate, you can deal with the issues relating to who comes, because it should not be that then that becomes the set norm that these are the parents because they were declared themselves as the parents there. That can be dealt with, and that can be kept on board, on hold. But you cannot not admit a child because of that, because there are many situations that children find themselves in. For example, somebody has kept a child with a woman with an understanding, kept the child with certain parents, or because she was vulnerable because of or maybe she was an unwed mother or something. Now, if there are any grievances that she has and these people have stolen the child or something to that effect, that's an issue which needs to be addressed, and it needs to be at a separate level. But immediately the child should not be denied education. So therefore, you go to a competent authority. So there were various competent authorities according to which department, like education with the education department, health with the health department, etc. So competent authorities under these laws. Now, under this law. Now then, of course, the children's court also. Now, the children's court would cover whatever is constituted as offenses under this law, which included sexual abuse, but also included other forms of abuse. Now, what are the other forms? For example, we talked of sale of children, for example. Now, that's not a sexual abuse, but sale of children should be an offense because somebody should not be selling children. It's an offense to kind of treat a child as a commodity and exchange money and buy a child. The adoption is a different procedure. That's not a sale. There's a procedure prescribed. So that doesn't leave room for all these machinations and for all these vulnerabilities for those children for, being maimed, to put in for begging, this, that, all these aspects. So therefore, these things had to be, of course, tried in a court, in a criminal court, but a court specially meant for children because the processes in the general courts are intimidating. Now, when we discussed this, we had visualized a jury, but there were different opinions within those of us who were involved in the participatory processes. And while we all may have broadly agreed that it should be a jury, we wouldn't have necessarily used the word jury, which got used there in the law. And then what happened is somebody invoked this because when the first case was taken up or something, somebody invoked the whole thing of banning of jury system in India. A very old provision in the law. Now these are as good as juries, but they're not called juries, and they're legislated. But then there was this ban on jury system, and the word jury was used. So therefore, they decided that you cannot have a jury, and you need to have a presiding officer and a court. Besides that, there is also the fact that when it comes to criminal cases, you can't have this, there has to be technical knowledge involved, etc. Otherwise, it will be decided at this level, and then and finally it will find an appeal or writ petition in the High Court where the whole judgment will get stuck down because it's a criminal case. Somebody is getting penalized, somebody goes to prison as a result of this. So there are certain technicalities and procedures to be complied with. So therefore, we said, yes, we have to retain the children's courts, but it will cover all these forms of abuse, as I said, not only sexual abuse. And that is where I will also give you, like as I said, sale of children, but also some more forms of abuse. For example, child abuse. Now, what is child abuse? I'm distinguishing this from child sexual abuse. Child sexual abuse is also covered under child abuse, but there is more to child abuse than child sexual abuse. So child abuse the definition. Child abuse refers to the maltreatment, whether habitual or not, of the child, which includes any of the following: psychological and physical abuse, neglect, cruelty, sexual abuse, and emotional maltreatment. Then any act by deeds or words which debases, degrades, or demeans the intrinsic worth and dignity of a child as a human being. Here are also the issues of intersectionality, because you also often have there have been situations where teachers have looked down on certain children who come from what Dr. Ambedkar called the depressed caste. So there was a need to address this aspect as well. So these things were incorporated within this. Similarly, corporal punishment was treated as an abuse. Then child abuse also included unreasonable deprivation of the basic needs, a child's basic needs for survival, such as food and shelter, or failure to immediately give medical treatment to an injured child, resulting in serious impairment of his growth and development, or in his permanent incapacity or death. So for example, if a child is taken to the hospital, people expect that somebody should be there with the child. What if the child is a street child who has got nobody? So then we had these kinds of experiences. So therefore, inclusion, we have to constantly bear in mind, because often when we work on a law, we tend to look at what our children experience, what the children of the caste or class that we belong to experience. We must widen our net. We must, even if we are not working with those children, we must make sure, if we are not working with those sections of children, we must make sure that the net is widened to bring on board people who are working with those sections of children, or people from those sections if nobody is working with them. Like if we were doing this today, we would have also looked at these nomadic tribes. For example, we have tribes who are not declared as scheduled tribes. They're this nomadic tribe, this Banarmare community, for example, which is the tribe that used to be called for shooting monkeys or dealing with the monkey pest situation in agricultural fields, etc. So now this community was nomadic because they used to be called here and there. Today, shooting a monkey is a criminal under the law, but so they are not nomadic anymore. So they are now stationed here. So now, what about those children? Again, those children face issues because they, for any other procedures, they have to produce, let's say, their parents' identity cards, but the parents have no identity because there was no issue about, there was no house that they could point to because they were living on tents on a piece of land for the last, let's say, 40 years. So then all these issues need to be taken on board. And then also for these things, you can't go to the court only for these things, because that's also quite a long run procedure. So there need to be administrative procedures that need to be get adapted. So which is why the question of competent authorities. Then we had also the State Commission for Children that we visualized. Now with the enactment of the National Commission for Protection of Child Rights, where state commissions are also visualized, that State Commission for Children still exists, but exists in the sense that the same body operates for both these aspects. But there are aspects that which are covered by the Goa Children's Act, which were not covered in that. So therefore, they operate at both these bodies operate. So therefore, again, this one is mainly to do with monitoring how the laws are implemented, various laws which have been enacted, including the Goa Children's Act. So then district inspection teams to inspect various kinds of homes, but not just homes, but various institutions that are dealing with children, to ensure that in the garb of institutions there is no exploitation, oppression or any kinds of situations for the children. Then then there were task forces to look at certain aspects, like for example, now you were just talking about the whole thing of what children can see or not see, and how can that be worked out, etc. So the law was supposed to have task forces to deal with this, special officers for let's say arresting people who committed particular type of offenses, and who are empowered to arrest, because everything can't be left to meaning you have to designate them. Like say for example, in the Immoral Traffic Prevention Act, you have special officers designated. They are police officers, no doubt, but they are special officers who are designated for these purposes. So similarly here, so that there is a body of a capacity, there is a body of people whose capacity has been built and who know how to deal with these situations. So that's why designated as special officers. Labor inspectors, because the whole question of child labor, then it involves those mechanisms which are generally available, because if you have separate standalone mechanisms here, then there is a problem, because there is an existing machinery. The question is, how can you address this within that? So the kind of marriage between the Children's Act and other legislation which touches on the same areas. So, and then state council. So all these various mechanisms were visualized. Now the question was, how to go about this process. What is the law making process? Of course, technically, the law making process is introduction of a bill in the assembly or in parliament, and depending on whether it's a state subject or a central subject or concurrent or etc. So that is there. The introduction and the passage of the law, that is in the final stage. Of course, you would have heard other lectures where they talk about how they the concerned linked departments are involved with doing all the groundwork and paperwork related to it, etc. So this is the general technical process, but we have felt time and again that very often these technical processes are not people friendly. They're not necessarily inclusive by that process. There have to be other processes that accompanied it, and therefore we demanded that we need to, first is the need-based processes. The need-based is, in this sense, I mean, by need-based, I mean that the children have the needs that emerged from whatever we were doing, the work that we were doing, etc., the areas that needed to get covered. So the need-based processes, like sexual abuse of children, you found that there was a tourist would bring tourists coming to Goa. Goa is a tourism destination, as you all know. So for example, the tourists would bring children to traveling with them. Now we couldn't do anything because can I not travel with my friends' children to somewhere? So then the question was that what is the system and how do we work that out? That, if somebody can be with the child, under what circumstances? Because this is how the abuse was happening. The tourist would bring the child is vulnerable somewhere else in some other part of the country, or even in other countries like Nepal or somewhere. Now those parents can't resist because they may be working for the tourists or working for a tourist home that is abetting all these processes. So they can't resist because they anyway have to earn their living. So then they bring the children here. They get abused. So that is at one level. Another level, as I said, here also many people can't resist, like migrant families, etc. So therefore, then we had to make sure that this process needed to be clearly defined. So that is why I say that because of that situation that was there, where these kinds of examples were there, we felt that these needs need to be brought on the table. These emerging concerns need to be brought on the table to have that composite legislation. And then so therefore, how to do it? Now, one is taluka and district and state level processes. So, now, of course, we also talk of village, not only taluka, but at the village and city level, up to down to that level in terms of resolutions to be passed in the panchayats, etc. Meaning, we talk of this also in terms of having a broader based discussion and engaging people in these processes. But at that time, when it came to the Children's Act, this is the level at which it was. So now the taluka level processes. Now here, I'm not talking of we as in, I'm not only talking of people, concerned citizens and women's groups, children's groups. The state was doing these processes, but we were inputting into what we expected in terms of the processes. So here were the taluka and district and state level processes. So at taluka level, basically the department was Women and Child Welfare Department. So the Women and Child Welfare Department was tasked with this. So they organized the state level process, the district level processes, and the taluka. But within that there were nuances, there were refined processes. So for example, at the taluka level, it was the Child Development Project officer under the ICDS scheme as it was at that time. And that Child Development Project officer would tie up with any one organization that is working, one or more organization, but usually it was one, that is working on the rights of on children's issues in that particular taluka for sure. So therefore, that's how different talukas organize these these processes. I'll come into a little more detail on that a little later. Then stakeholder processes. Now here, yes, in the taluka level processes, we try to involve the stakeholders, but who's the main stakeholder is also needed to be identified. So main stakeholders are children. Children's Act, they are the main direct stakeholders. So now if they are the main direct stakeholders, their voices need to be heard as well. So the point is, so therefore there was one there was a stakeholder consultation of just children. They articulating their voices like a children's parliament kind of. So these were some of the processes. There were also other processes because one had to kind of look at these things needed to be vetted by at the law department, etc., which is there otherwise also, that the law department has to see that it's not an unconstitutional law, that the provisions are not unconstitutional, etc., etc. So there were all these other processes as well. So now need-based processes I've also already talked about. The taluka and district level processes, as I said, the CDPO in collaboration with organizations working on children, each worked out their own context in consultation with the taluka CDPO. Some people called just the children's rights groups or groups with departments that were like women and child department, CDPOs or Anganwadis, etc. Other talukas were involved, like say, for example, the taluka in which I'm a part, we involved the people who are working at various in various spheres, like in education, etc., and also the authorities who have already also engaged with the law, because they may point out that, oh, how will we work this out? Is that possible within our system? So we will hear them. Of course, we can, many times there are resistances because you're trying to break out of the usual mold. So they'll say, how can we do this? This can't be done within the framework of this. They may not be speaking as lawyers, but they're speaking as typical bureaucrats sometimes who are conditioned and have a one-track mind. So but then there's no harm in engaging, because there are bureaucrats who also have experience, and whatever their experiences, so that we know how we can pitch it and how we can specifically also see that the law takes care of it. So therefore, that was a useful process where we brought these people on the same table, that is from the concerned government departments, and drawing from the experiences of stakeholders and authorities. So at the taluka level, at the district level, and at the state level. Sorry. Okay. Yes. So having said that, so this is the way in which we try to work out all this, that how can we be inclusive? How can we be inclusive in terms of the content of the law, and how can we be inclusive in the entire lawmaking processes? Now, just to also share, there were also some limitations, and also the challenges that you face, that that various people face, where the whole thing, there's no problem if it is political positions, if political positions are constitutional and child friendly and friendly with all the intersections of as far as children are concerned. But sometimes you also have petty politicking. So also you also have situations where, for example, we were asked that there's a few days left, and I for one was told, can you put a law together where it's the chief minister's birthday, in another 15 days. So so then we have also to be able to say, first of all, 15 days is too less a time. And secondly, why should we rush through this because of just to give that chief minister some credit? I mean, I'm not concerned purely on the credit, but it's also that you have to make sure that the process is that the whole law is not a waste of a law, a law that does not serve any purpose or does not take anything into account. So these are the difficulties that you also face along the way. Also, that people try to isolate in this whole process. The state tries to isolate people and create distinction, divides within the groups that are consulted, within people that are consulted. We have to be wary of this, because we should know that this is our objective, and we should not be drawn into those divisive processes. This is something we have to take great care of, whether as civil society, whether as policy makers, at whatever levels, we have to be alert to that. And no one can do anything. Yeah, at best they'll transfer you to Andaman and Nicobar Islands if you're an administrative officer. That's what they do as far as Goa is concerned. Like if somebody who is an IAS officer or an IPS officer, sort of does not toe the line of the ruling dispensation, they transfer him to Andaman and Nicobar Islands. So that's the kind, or Lakshadweep or some, some such places. That's how the policy that they follow with reference to Goa officers. So, but I think one needs to stand up to that. And anyway, if you have signed up to being that officer, you have signed up to being posted in all these places. So the persons who are in these policy making positions need to stand up to that. There's nothing that the law can do. You'll have to fight. I know it's a struggle. We know it's a struggle. Sometimes we may have to be strategic in terms of how we place it. Maybe not the same style as an activist places it. And they may find other language to kind of make sure that they push it through, which is what also happened in Goa, that there was a secretary for women and child, one Mrs. Reena Ray, who tried to bring up, who tried to push it at the level, and that was a time when at that point of time, it was a BJP-led government that was in power, and there were groups that have different affiliations and politically, but at the same time, we wanted the Children's Act. Should we say now we don't want the Children's Act because it is going to be enacted by a BJP government if some of us don't subscribe to that particular politics? No, so long as these processes are democratic, the state, the governments, we have to ensure that democracy functions. So if somebody is going to get a credit because of that, then good for us and good for them also, because then they're forced to be democratic and recognize that they have to take all these stakeholders into account. So these are some of the challenges we did face. Another set of challenges, because this is so wide, as I said, all laws guaranteed, all rights guaranteed by the Convention on the Rights of the Child. Therefore, all the mechanisms have to be taught out in detail. They have been taught out, but they have not been taught out in that much detail. There are areas that maybe none of us who were actively engaged with the process were familiar with. So like, for example, how do you deal with a situation where children are exposed to internet? And of course, that was not the time when people had mobiles. Children had mobiles to deal with, to kind of attend class. This was even not at that time. But still, as the previous speaker also said, we have also to consider the time, the changes in time, etc., changes in space and time. All this needs to be considered. But so in terms of that, there are mechanisms which are like,
Hello, Albertina, we have lost you. We can't hear.
Yes, I think connection issue. I will just check with ma'am.
Hello, Albertina.
Ma'am has dropped out.
It has started raining. It's windy and raining.
Now ma'am has.
Yeah.
Can you hear us, Albertina ma'am?
She has joined here. Please unmute. Albertina, please unmute yourself.
Am I audible?
Yes, now you are audible. Yes.
Okay. Yeah. So we had to make sure, we have to constantly make also sure that inclusive process means that every section concerns need to be constantly monitored also after the lawmaking. So it's also not just lawmaking, but it's also the follow-up at these levels. So with that, I will end my presentation.
Thank you, ma'am, for such an insightful and enlightening session. Now I request the chair, Professor Vibhuti, to share her remarks.
Hi, Dr. Albertina. I know you have been working on this issue in a very, very courageous way for past 3 decades. Even when you invited me twice to Goa, and that time also you took you were fighting for against the trafficking of children. My major concern is, especially like our experience in Mumbai, is that in the class where there is a caste-based discrimination against child, should we go for SC/ST Act or should we go for Juvenile Justice Act to get them justice? Because teachers discriminating between the children of Shudra caste and also sometimes beating them up. We have also come across the case where the highest marks the child from deprived section got, and instead of congratulating him, the teacher said extremely, you can read the Vacha and Dutch Institute, their report. No, we have done the first participant. Second one is that we don't, even for when it comes to statistics on children, gender-based differentiation you don't get. So gender-based data, how many girls? Now we are getting at least city-wise. This year we got, at least last month, that how many girls are missing in different city. Ahmedabad, it all started with Gujarat and now Bombay now. So can we get far more deeper classification of statistics and indicators about children's problem? And the third one is that where does this thing about children exported to Gulf, like cross-country trafficking of children for camel ride, for jumping into the water bodies, and some dangerous acts with the fire and all which children are made to do. And even on the street, no, when the DTNT community, their nomadic communities and all, they make their children do some of the very difficult tasks, no, tightrope walking and all that. Where does it figure in Juvenile Justice Act?
Yeah. So the thing is that we realized, of course, that the present Juvenile Justice Act was not there at that time, but still, even now, these aspects are not addressed. That's why we in the Goa Children's Act, we got this provision introduced of child abuse, so that it covers and also defined these sections. Now, as far as SC/ST Act is concerned, the first question, the SC/ST Act does cover this, of course, clearly. And I think that if it is very clear, but the SC/ST Act has got a qualification, that in the sense that if the child who is abused by somebody else who also belongs to the SC/ST community, then it doesn't come within the scope of this act, because then it is perceived as it's not a caste-based discrimination. It's like, suppose the teacher beats the child. Then if the teacher beats the child, there's a corporal punishment provision, for example, in the Children's Act. And today it is also corporal punishment is, I understand, banned in not allowed in schools. So there is a law for that to deal with corporal punishment. To add to it is the dimension of caste. So for that, I think so that there need to be, that we need to take on a few cases which are hard hitting to get to drive the message not only to that teacher but to teachers across the country, that this is not done. You cannot discriminate, because here is the element of both corporal punishment and discrimination on the basis of caste. Right. So therefore, I think in such cases, the SC/ST Act needs to get used. Okay. And where one more stringent provision is there, the other doesn't dilute that provision. If the other law doesn't dilute that provision anyway, right, because these are also special laws. Yeah. That is as far as this aspect. Regarding gender disaggregated data, precisely because of this issue, in this section in the Goa Children's Act, we had put it out. And I think maybe, I do not know, maybe you can guide us, Dr. Vibhuti, about the Statistics Act, whether it has any provisions or not. which require this data by law, not simply as a policy thing, but by law to be put out in a disaggregated form. I've really not looked at that. But we knew one thing, that gender disaggregated data at that point of time, this law was enacted in 2003 and wasn't there. So as I said, our provisions, the provisions that have come in have emerged from the experiences and needs. And therefore, like say, because, in Goa, like for example, they should say, oh, there's no discrimination against girls in Goa. Goa is very forward, but it is the son preference is there just like in any other part of the country. So therefore, in a section on the law relating to girl children, so it's not just about covering these sections, but it's about what we are covering in these. And therefore, in the section relating to girl child, we incorporated a provision which says there was a provision which we got incorporated about gender disaggregated data. I was just looking for it. I'm not, yeah, we have a thing under other provisions, prepare disaggregated, not only on the basis of gender, but also prepare disaggregated data on all children in Goa in terms of category, age, sex. So that kind of requirement. I'm sorry to say that much of that is not being implemented. And we are at the moment passing through times when we have to run to deal with from one thing to another that is being that is there on the firmament. And also, I mean, given the vast scope of this, that to actually hold on to this, and therefore there is ample scope for people who are interested to work on these areas to take on some of these things and pursue them intensively. But we have these provisions here in this law.
Thank you, ma'am. I request Advocate Dr. Shalu Nigam to share her remarks as well.
I think it's a very wonderful presentation, very insightful presentation. And, it's not only in Goa, we should have, this kind of legislation in all the other states, and even at the national level, I don't know if, this could work, and, at least the rights of the child, could be taken care of in such a comprehensive manner. But just one thing I would just like to state about, this during the COVID, we have seen a lot of COVID orphans, who are there, and there was some data which was shown during that time on the television. That National Commission for Protection of Child Rights, they have collated some data, and the policies. I don't like, they have. They said that they are making the policies about that, but I think each state have different kinds of provisions for such kind of groups. So in Goa, definitely, with this kind of law, do you think some kind of differences there? If we talk, say, about in Delhi, like what kind of, if this law could make a difference in that kind of situation. And secondly, about say in North India, we have a lot of this problem of child marriage and similar such issues, very patriarchal kind of issues are. Maybe Goa is something very different. So if we have to implement such law in, say, in North Indian state, then what should, how should we go about that? Because child marriage is something which is more related to family also. It's all about the state authorities, but also about the families also have to play a role in such kind of situations. So if any kind of in your experience, if you have seen that kind of situation.
So I think I mean, we discussed that also, because we had cases, a couple of cases of child marriage, mostly by migrant when it comes to migrant children. So we discussed this aspect, and we had also defined, we had a lot of discussion in defining what should be the age of the child. And then, of course, we had to make the exception for rape, because in terms of statutory rape, the Indian Penal Code anyway applies. So we couldn't couldn't really look at modifying that. But But when it comes to marriage, now again, as I said, it's not the marriage per se. That the national law applies anyway about prohibition of child marriages, etc. But there also we bumped into the whole thing that what do you do? Here first you have a mindset that a girl, especially if it's girls, have got to be married off, finished, our obligation is over, because there may be problems getting because of dowry and etc. etc. There may be problems finding a person who will marry, especially poor migrant children, girl children. So that was one aspect. The second aspect was that as far as their vulnerabilities, because they cannot also afford some economic backup to the children. So they're looking at to the especially girl children. So they're looking for like fast forwarding these processes. So now in this situation, that means we have to address their vulnerabilities. So just criminalizing various acts does not suffice. More so now, I would say I would be considered very dangerous, because this criminalizing will be used to kind of meet targeting of certain sections that the ruling dispensation does not approve. So therefore, the question is, how do we make sure that the vulnerabilities that result in people doing these things are addressed? This was the thing when it came, and therefore we brought in the provisions about education, health, all these issues, that there are adequate provisions so that people are not put in a situation where they're vulnerable and have to then marry their children or get their children married off at a young age. So that was as far as child marriage goes. The other is what you asked was about
COVID, orphan
COVID. Yeah. So now that did help in some ways, because when, for example, if somebody said that, because there were also that the whole question of who will accompany the child. So there were all these kinds of issues. So the provisions relating to one, that we incorporated the rights of the child. So the child has to be treated, whether there is a parent, whether somebody is coming to take responsibility for the child or not. As I said, like education, you can't not treat a child because there is somebody not accompanying. The child has rights on their own steam. So therefore, they cannot refuse somebody being admitted. Now, I know it is a challenge for even a well-meaning governance, that in that situation where there's such a this thing of eruption of so many cases and need for hospitalization, it would be difficult to find the what you call that the staff, the technical people to deal with these situations. But that is where we also discussed and talked. There was a group formed that is not really only on children, but there was a group. It was basically operating as a WhatsApp group, because those were the times. There was a WhatsApp group formed, which was called Goa COVID-19 COVID-19 Goa People's Response. I was kind of coordinating that group, and we put up representations in different spheres. So we put up one representation on all the health concerns, because there was also another situation then that if you had COVID, now you had to be attended, but all the other illnesses, you have to keep them standby. Now you can't, if suppose a child has cancer, now you can't say, now you wait, we will only deal with the COVID cases. So we said that we can't have these processes emerge where you have this. And that you can take people now. There were people who were volunteering. There were doctors, private practitioners, etc., who are volunteering. I mean, in a situation where you don't get people volunteering. Even those who are working, they did not want to work because they will contract COVID. There are chances of contracting. So here, when there are people volunteering, you have to have a system where you should take them on board. It's a system for an emergency. So it's not a. So here it's not a question of you're having contract labor or something like that, because here is an emergency situation. So we said, we also said we are ready to give names. People were volunteering, we are ready to give names. Now take them on board, because you are running out of staff and you are coming with all these things which are having implications for especially the vulnerable sections of society. So this is how we went about it.
Thank you, ma'am. The floor is now open for questions from the audience. There aren't any questions.
I already had that question. Let me bring him. No, he's not here. Okay, go ahead.
With the chair's permission, we would like to move to the vote of thanks.
Tina, you have to answer. Third question is about cross-country trafficking. Yeah. Hello.
Yes.
Albertina, about the cross-country trafficking for camel ride and jumping in the water and playing with fire and all that, that's happening in a big way.
Yeah. So as far as the cross-country trafficking is concerned, there we had a limitation because this is a state law. But we, to the extent that anybody is brought into Goa, they have to have an explanation of why they have that child with them. That was the thing. But I would say that these kinds of aspects need to come up in other parts of the country as well. Because what happens is, when you traffic a child, you have not only to traffic the child, but you have to prove that that person trafficked the child for this purpose.
Yeah. So destination and supply, the origin, both of them have to be in tandem. Yeah.
Yes. And then also the vulnerabilities. So something like this was done when it came to fish workers. Because fish workers also, are put in vulnerable conditions and things. So there was like a tripartite thing where also the source point, there was this discussion that the source point where they're being recruited, they need to know what they're going into and where they're going into and how their rights will be secured.
Yeah, in fact, even Operation Help in Mumbai by Mumbai police had a tripartite body because of there were so many girls from Nepal were there. Bangladesh also they were there. So the respective government from there, Indian government, it's the Ministry of Home Affairs in Bangladesh, Ministry of Home Affairs in India, and the police and army, they all were involved. Yeah, that's what it's very important. Embassies have to play a very important role, and Home Affairs, Ministry of Home. Yes, yes, but it's possible. It's doable. Yes. Thank you.
Thank you, ma'am. Now I request Professor Vibhuti Patel to give her closing remarks for the session.
I think in the closing remark, I would like to say that today we have taken the most neglected area because children are to be seen, they are not to be heard. That's what Freud had said. And I think the same logic continues even in the mindset of our movers and shakers of the country. So children are always like, their concern, their crisis, their challenges, they are not taken seriously. Even when we discuss with the local self-government bodies, they also say, ma'am, talk about population control rather than talking about child rights. So this is the way cynically both governance structures also respond. And that is why I think person like Dr. Albertina and Dr. Ghuge, they are the conscience keeper of ours, because unless we give them healthy, mentally, physically healthy life and also their well-being, then country's future is very, what kind of future are we going to have for our nation? They are the future citizens of our country. And that's why both the sessions about the Juvenile Justice Act as well as the Goa Children's Act, we have to learn a lot about Goa Children's Act. I would like to remind Dr. Albertina that you were the first one in our country to come up with the demand of comprehensive definition of sexual harassment at workplace based on your experiences of Bailanchosar, where Chief Minister was accused of harassing his secretary. And that was the time nobody in India talked about it. I remember you made presentation in the National Conference on Human Rights in 1990. And by 1997, we had Vishakha Directive. So I feel optimistic that once you start this kind of discourses and take them through training programs and such programs, we take them to other states, they also get the confidence that if Goa can do it, why can't we? So I think with that optimistic note, I would like to continue the session. Thank you.
Thank you, ma'am. With the chair's permission, we can go for the vote of thanks.
Please go ahead, Nikita.
As we have come to the end of the day 11 of the Law and Public Policy Youth Fellowship and Online National Summer School Program, a 2-month online immersive legal awareness and action research certificate training course and internship program, I, Nikita Bhardwaj, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our expert for the day 11 session, Professor Sharmila Ghuge and Advocate Dr. Albertina Almeida, for taking out their valuable time and giving us an opportunity to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel, and lead advisor, Advocate Dr. Shalu Nigam, for convening the session. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you this Friday, that is 7 July at 11:30 a.m. for our 12th day of the certification course by distinguished experts, Advocate Flavia Agnes and Dr. Rashmi Singh. We are grateful if you are watching us later on YouTube or listening to us on our various podcasts or reading our publications. We hope you continue to join in future to our IMPRI #Web Policy Talk and #Web Policy Learning. Wishing you a good day. Thank you.
Thank you. Thank you. Thank you.
Thank you. Very nice session. Thank you. Thank you, Albertina.
Bye.